Dr. Cortez did testify at the writ hearing. He was Andrew's treating physician, the only one who treated him while he was alive, and he testified that Andrew was not a normal child, that he was delayed, and when he was made aware of all the records of Sharon Hamill taking him to MHMR and early childhood intervention, when he became aware of those, that he came to the conclusion he was mentally retarded or had an autism spectrum disorder. And he said that because I wasn't aware of all his medical records when I treated him. We had a medical record changeover in my office when my son saw him briefly, but then when I provided all those records to him, having discovered these initials, early childhood intervention, and the subpoena in those records, Sharon Hamill was bringing Andrew in because he was slow, he was tantruming, he's slower than other children, I don't understand him, he doesn't know the difference between boy and girl, and so there's a clear indication that this was a special needs child. And Dr. Cortez,
foster children that Sharon Hamill fostered?
Depending on which testimony, 200 to 300 foster children, so she would know.
To seeing and dealing with a wide spectrum of children. Let me just go back to something that's been, I think, very strange. What is it that Ms. Overton said that she fed Andrew the afternoon that he died, or the afternoon he went in hospital?
That she fed him some soup.
And what was that soup?
It was, as I understand it, just out of the canned soup, diluted, and with a little sprinkling of Zatarans in it. And he ate the entire serving left over from dinner the night before.
Okay, and then what did she feed him after that?
Then she poured a large tumbler with water and sprinkled some Zatarans and thought, that's too much water for his tummy, I'll cut that in half, put it in a little sippy cup, which we all know doesn't pour. You have to suck on it to get it to pour. So, that's the purpose of a sippy cup. She put it in a little sippy cup, this mostly water mixture, and he drank that, a couple sips, and threw it down.
Okay, the state referred to that as a slurry of Zatarans and water.
Yes, ma'am, and that's what the stomach contents tells us she did not feed him. They're right when they say that what killed him had left his stomach. That's right. He had eaten it earlier himself, and what he had in his stomach was that soup. That vomit, you hear the testimony of Ms. Gonzalez and Nurse Erkan at Driscoll Urgent Care. It's this soup that's coming up that she just fed him, and that's low in sodium content. It's proof that she gave him what she said she gave him.
Are there any fact findings or statements of fact with which you disagree in the record?
The trial court's advisory statements of fact and conclusions of law, of course, recommend I don't get relief and find against me on things where I don't think there's any support for the facts that the court recommends. And that's why I filed extensive objections to every one of the court's findings of fact and conclusions of law. I don't think the record supports it. In addition, Your Honor, with regard to amendment, I'll remind the court we're talking about braiding claims here, in Banks versus Stretke allows us to raise these as we discover them, and of course that's what we did. To note that samples from photos are switched, and that's why I put the photos in the brief. You can see when you match it up with the Emmy's legend that these samples are not as represented. That the Zatarans with little water, that's that low 48, is sample D, and it's actually E, the 250, is the child's stomach content, as I said, showing that Hannah did feed him what she said.
Ms. Orr, but if I'm understanding the state's argument, they're saying the jury convicted her of omission, which means that he stopped breathing and then she waits an hour and a half to take him to get care. And so all of this business about the salt and the stomach contents and what she fed him and when she fed him really is immaterial to the question of was she guilty of omission, meaning that he stopped breathing and she didn't take him to the hospital.
It was the state's theory. It argued and questioned Hannah and closed on forced feeding. But if we take the poll of the jury and examine omission, Andrew did not stop breathing until moments away from Driscoll Urgent Care. How do we know? We know because, first of all, she testified he was breathing. Kathy Holler, the next door neighbor, came by, saw him, heard him throwing a fit on the phone when she was calling Hannah saying, I need to pick up a diaper for Sebastian. We know because when the Overtons are in the car taking him to the urgent care center, Hannah's on the phone with Anna Ballou saying, I'm going to need those the CPS records that allow me to get medical treatment for him, which she wouldn't need if it was an emergent situation. We know that because Dr. Moritz stated that the symptoms of sodium intoxication are going to be mild and not lead a parent to provide emergent care. This is the testimony the lawyers did not put on Judge Ocala, but it's clearly, that's the science. And in addition, we know because Larry called his mother and said, oh, I'm on the way to Driscoll Urgent Care, it's not Driscoll Children's Hospital, and all these phone calls are being made. Hannah could not have been giving CPR and mouth-to-mouth resuscitation to a non-breathing child if she's making these phone calls and asking for records needed to admit a child under non-emergent conditions. And we know most importantly from the science, Spawn Hospital, the second hospital that got him, records he had a temperature of 96.2. Too high a temperature for a child to have been not breathing for an hour or 2 hours, as the state suggests.
How is that consistent with the fact that his pupils were warm, his skin was blue, and he was limp, but he was cold to the touch?
Because the extremities were not circulating blood. Everything was going to the core functions, as Dr. Moritz had testified, not again in front of the jury, but the reason is because the body's trying to preserve itself and keep the brain functioning and the heart functioning, and so these extremities were not getting as much circulation. As Dr. Moritz said, the body functions, all the organs are shutting down, even the stomach that preserves this last thing Hannah fed him.
So that's why he was cold. Why were his pupils dilated? And there wasn't their testimony that he would have had this cardiac arrest sometime earlier, for his pupils to be the size that?
No, ma'am. There's no evidence that the cardiac arrest happened earlier. The evidence was that that Dr. Rhoda testified about was, I got news that he's been transported from Spawn Hospital, the second place, in cardiac arrest. That's the cardiac arrest testimony. And I'm sorry, Your Honor, I forgot the second part of your question. And so this information was, sorting it out would have been important. As to communication, these lawyers, there were 7 of them, but it's clear they didn't communicate. Mr. Gilmore said, well, I presumed, it was assumed, that Jones and Pinedo were going to take care of the medical evidence. And Pinedo and Jones says, we were advising Gilmore about the medical issues. And then Jones says, well, things changed about discovery, and Brad Condit was taking care of discovery. And Brad Condit said, well, Jones was going to take care of these complex medical issues. And when it came down to it, every single lawyer said, I didn't attend the deposition. Pinedo couldn't have. He was cross-examining Dr. Fernandez, who was being put on the stand at the very time that Dr. Moritz was being deposed. Stiff was saying, I'm bouncing back and forth, taking care of these objections because I don't like what Sandra Eastwood is asking. The only one in that room is Brad Condit, and no one asks him, no one watches the deposition, no one reviews it until right before the hearing. And then Jones, who was the expert, says, this was a mistake, and I was ineffective. And lead counsel agreed.
I'm going to ask you to forgive me for not remembering what your objections say, but there are a couple findings of fact. One is that Dr. Moritz's testimony might open the door to evidence and testimony harmful to the defense that was otherwise excluded at trial. Cannot be said to be ineffective in choosing to exclude Dr. Moritz's testimony from trial, especially when the excluded evidence concerned child abuse. And there's another finding that it became clear that Dr. Moritz, during the state's cross, did not review all the evidence in the case, including but not limited to Hannah Overton's children's testimony or Mr. Overton's interview regarding Hannah's discipline behavior. Did any evidence of what the children said or the disciplinary practices of the Overtons ever get into evidence?
No, Your Honor, but I believe that Dr. Moritz did review the interviews of the children. The problem with Sandra Eastwood's questions, and are encapsulated in that finding of fact, is that they had no basis in fact. There was no testimony and no evidence and no recording of any person saying that Hannah Overton used salt to discipline her children. None. And that's why the lawyers were concerned. It could have been edited. It could have been put on as David Jones testified.
One last question.
state has said that all the bags or bottles or cans or whatever, all this medical evidence were labeled with the home address. Do you agree with that?
I do not, because I went and saw medical evidence. I saw from the medical examiner's office how that was labeled. And keep in mind, the way I found this was Diego Rivera. He gave me a tag number, and that's what I tracked down, and that's why I knew. When it said the Overton's home address, that was my target. That's where the vomit was, and that's why I grabbed the scissors and opened that bag. So, no, I don't agree with that. And I think if we look at the chain of custody documents, we'll see that that's not the case. Thank you very much.
Counsel.